Okay, well, I'd like to make sure we have the full hour, so I think we might get started while people continue to log in for the next few minutes. Good afternoon, everyone. I'm Peter Danshin, Associate Dean for Research and Faculty Development. I'd like to warmly welcome everyone to this, which is the fourth in our new faculty webinar series, which today is on the topic of access to justice in a time of uncertainty. It really is wonderful to see so many students, both current students and incoming students, as well as alumni and wonderful alumni, including on our panel today, as well as staff and faculty and members of the broader Maryland legal community participating in the webinar today. I'd like to say a special word of welcome to incoming 1Ls and new students who, hard to believe, will be seeing this Friday for the start of orientation for the fall semester. The aim of this webinar series is for members of our faculty and broader community to address timely, significant, and other issues and speak about their scholarship, clinical work, and research projects. And our real hope is that this will provide a regular forum for everyone to really learn about and remain connected to the intellectual life and work that's going on at Maryland Carey Law. Our next webinar in the series, just to mention for those keeping track, will be on September 9, which will be a conversation between Professors Tanya Banks and Paula Monopoly on Professor Monopoly's really exciting new book, which has just come out, Constitutional Orphan, Gender Equality and the 19th Amendment. And that webinar will look at issues at the intersection of race, gender, and class, and the really complex history of struggle for full citizenship in the United States. So please put that on your calendars. But today, our conversation is about access to justice. And I would like to introduce Professor Leigh Goodmark, the Marjorie Cook Professor of Law and co-director of our clinical law program. I'm sure Leigh is known to virtually everybody on this call. But she writes and teaches courses in family law, gender in the law, gender violence, and justice at the intersection of social work and law. And I really literally can't imagine a better person to lead us today in this conversation and to address this, this critical topic today. So I'll hand over to you, Leigh.
Thank you. Excuse me. Thank you so much, Professor Danshin. And welcome to all of you. It's lovely to see all of you here. We are talking about access to justice today. And as you know, access to justice is challenging at the best of times, and these are far from the best of times. The challenges that we are facing right now are particularly acute. And our panelists, I hope, are going to give you a sense of the issues that they're seeing in their practice areas, and importantly, also what you can do about it. And so I'd like to introduce our panelists, and then we'll jump right in. We plan to talk for about 40 minutes or so, and then we'll turn it over to you for questions. I'll monitor the chat for questions as well, so we'll make sure that you have an opportunity to get your questions answered. So our panel today, Professor Kerri Lowrey is the Deputy Director and Director for Grants Research for the Network for Public Health Law, Eastern Region, based at the University of Maryland Francis King Carey School of Law. Professor Lowrey has more than 20 years experience as a public health lawyer. She received her JD from the University of Maryland School of Law, an MPH from the Johns Hopkins University Bloomberg School of Public Health, and an AB in Public Policy and American Institutions from Brown University. Professor Maneka Sinha directs the Criminal Defense Clinic at Maryland Carey Law. The clinic represents indigent Baltimoreans charged or convicted of criminal offenses. Prior to joining the Maryland Law faculty, Professor Sinha spent a decade as a public defender at the Public Defender Service for the District of Columbia. Professor Sinha received her BS from the University of California, Berkeley, and her JD from NYU School of Law. Reena Shah is a longtime advocate of social justice and social change who has served as the Executive Director of the Maryland Access to Justice Commission since November 2015. Ms. Shah is also currently serving as the Vice Chair of the Maryland Attorney General's COVID-19 Access to Justice Task Force. The Access to Justice Commission unites leaders to drive reforms and innovations to make the civil justice system accessible, user-friendly, and fair for all Marylanders. Ms. Shah earned a BA from the George Washington University, an MPA from Princeton University, and a JD from the University of Maryland, Francis King Carey School of Law. Welcome to all of you. Thank you so much for taking the time to do this today. So we're going to jump right in with the question of what is the most pressing access to justice issue that you are seeing currently? And each of our panelists is going to take some time to talk about that, and then we'll follow up with some questions from there. So Professor Sinha, what is the most pressing access to justice issue you're currently seeing?
So first of all, thank you, Professor Goodmark, and thank you everyone for joining this conversation, which I think we all agree is especially important in this time of extraordinary upheaval in our history. And so I want to start by framing it with, there's no single issue that is inhibiting access to justice in this time. The COVID-19 pandemic has turned the criminal legal system entirely on its head. It is not operating in the ways that we have come to expect it to when, as Professor Goodmark said, there are already hurdles to access to justice in the best of times. And so I want to focus on a couple of discrete issues that I'm seeing and then sort of think a little bit a bigger picture about that. And so the first issue that we're seeing involves issues of access to counsel and right to counsel. So by now we all know that that indigent defendants, or all defendants who are housed, who are residing in jails and prisons around the country are living in some of the worst COVID-19 conditions of anyone in the country. Jails and prisons have become hotspots, and I want to think about who it is that we're housing. So predominantly the populations of our jails and prisons are poor Black and brown people. And all of those people, what we're seeing is we know that there's difficult to just be healthy in those types of environments. But the added layer is that cases are being pushed off to months on end indefinitely. And a big issue is that the indigent folks who are in these facilities, or anyone who's in these facilities, their ability to communicate with their lawyers has been severely diminished at this time. So normally where you have in-person visits where a lawyer can speak with, build a relationship with a client, in most jurisdictions around the country, this is happening predominantly by phone now. And that's created a number of layers of added hindrance to the ability to communicate with your lawyer. So because staff needs to transport people in socially distant ways, and they need to be present for some of the, or available to monitor these things, the amount of time that lawyers have to meet with their clients or speak with them on the phone has been limited. The number of times lawyers can speak with their clients in a given week has been limited. A lot of facilities are distributing calls. Certain agency gets a certain number a week, certain agency gets a certain number a week. So the inmates are having a difficult time really being able to understand their cases. And the second layer on top of just the inability to work with your case with your lawyer is that there's restrictions on seeing the actual evidence that's going to be presented against you. So because these meetings are happening by phone now, detainees don't have access to the actual discovery or the evidence that's going to be presented to them. And sometimes there's an ability to view some of that via a video visit, but as we all know, sort of interacting over a video call and looking at things like body-worn camera or police documents is especially difficult under those circumstances. So there's a number of added dimensions to that initial phase of building a relationship with your client, and being able to work with the lawyer on the case. That translates over to the courtroom as well. So there are a few jurisdictions that have resumed in-person hearings, and sometimes what they're doing is, for the safety of staff and lawyers, they're transporting the defendant from a jail facility to the courtroom, but the lawyer is not coming in, which is a reasonable decision to make for health and safety reasons. But that creates an added dimension of inability to work with your lawyer on your case, because you're in a courtroom with a judge who might be asking questions, It's difficult to consult with your lawyer. And so all of that is trickling down to sort of layer after layer after layer of inability to really get meaningful justice in a case. And so how are some of the facilities dealing with these problems, and how are they trying to limit the spread of COVID, which has been such a problem across the country? In certain jurisdictions, what they're doing is they're putting our clients in lockdown or in isolation for 23 hours a day. And that's, you know, of course, a huge burden. I mean, it creates a tremendous amount of mental health and physical health issues. And then it adds to that dimension, leaving clients with only an hour a day to do things like call their family, wash their clothes, take showers, and if they need to, reach their lawyers. So I'll stop there. That's one of the most prevalent issues that we're seeing, is just access to counsel and right to counsel rolled into one, and how that trickles down into every layer of the criminal process.
Thank you, Professor Sinha. Professor Lowrey.
Thank you, Professor Goodmark. I want to echo what Professor Sinha said and say that, you know, there's nothing new under the sun, right? So these access to justice issues, most of them are not new. COVID-19 has kind of taken problems and disparities that have always been there and either exacerbated them or just shined a giant spotlight on them. And that's really what we're seeing in the area that I've been doing most of my work, which is the significant housing crisis that we're facing. The risk to housing stability for millions of Americans due to primarily to their inability to pay rent, particularly as eviction moratoria are being lifted across the country and courts are reopening and starting to hear eviction and failure to pay rent cases. So the problem is really reaching crisis mode. The Aspen Institute estimated that between 30 to 40 million people are at risk of losing their homes due to fallout from the pandemic, either through eviction or foreclosure. And for us in the field of public health law, this is particularly problematic because research has shown a very strong correlation between housing and health, primarily along four main pathways. And this research comes from an article through Health Affairs from 2018. But those four pathways are housing affordability. So can you afford to live in a healthy area? Conditions inside the home, because exposure to lead and water leaks and mold, dirty carpets, pest infestations, all of those things have really significant impacts on health. Residential crowding is another major aspect related to health that's been linked to both physical illness and also psychological illness, and the ramifications for pandemics in a time of pandemic and for infectious disease spread when you're talking about significant residential crowding is obvious and of particular concern. The third pathway is neighborhoods. So what are the environmental and social characteristics of where people live? All those things are really closely correlated with health outcomes. And the fourth is really what we're concerned with when we talk about eviction prevention, and that is having a stable place to live. So housing stability. We know that unstable housing among youth is associated with a number of adverse health outcomes like teen pregnancy, early drug use, and depression. For all ages, unstable housing is associated with disruptions to employment, social networks, education, and receiving social benefits. So we know that providing access to stable housing improves health outcomes and can reduce healthcare costs. There's a lot of research out there that shows that cost is very cost effective to make sure that people have stable housing. Lawyers play a really critical role in making sure that people have safe, secure, healthy places to live, particularly right now, because we don't know how courts are going to handle high volume dockets like rent court. It's all the more important for people to have experts to help them navigate through this process. In a recent South Carolina Law Review article, which I'll actually put in the chat from last year, Frank Griffin goes so far as to call attorneys healthcare providers as they apply housing laws to ensure stable housing for those in need. Because attorneys can help address these issues by assisting with legal issues like housing assistance, eviction prevention, debt-related problems, habitability concerns, issues with landlords and disability-related housing concerns and the like. I also just wanted to finally illustrate that the Public Justice Center commissioned a report that came out a couple of months ago called the Stout Report, which many of you have probably seen. It's excellent. It shows that 99% of tenants in Baltimore City District Court were unrepresented. And so that just highlights, and this is pre-pandemic, it highlights the problem that we have here with access to justice and making sure that people have access to legal representation when they're facing these really scary times. We also know that at a minimum, having access to counsel in eviction proceedings results in more favorable outcomes for tenants and the decreased likelihood of experiencing homelessness or living in shelters, among a host of other issues. But in the interest of time, I will stop there, and I look forward to your questions and further discussion.
Thanks, Professor Lowrey. Ms. Shah, what do you think the most pressing access to justice issues are that you're seeing?
Great. Thank you, everyone. So some of what I will say has already been covered, but I want to put into kind of sharp relief. I work in the civil justice space, and Professor Sinha talked about the criminal justice space. And in the civil justice space, there are so many different issues that have been impacted by COVID. So I'm just going to put some numbers out there for you. Roughly 900,000 Marylanders have filed for unemployment since March. Over 150,000 Maryland renters have lost their income due to the pandemic. And so there's an expectation that about 42% of renters are going to be facing eviction. The Maryland Food Bank estimates that 980,000 or more Marylanders will go hungry or have less access to food. Now, what does that have to do with access to justice? It is completely related to the civil justice system because these are the conflicts that are raised when you can't pay your rent or you lose your job and then you have to file for unemployment. Those fall within the civil justice system. And as Carey was just mentioning, you do not have a right to an attorney. So what Professor Sinha was talking about is you can't have access to the attorney that you have a right to if you can't afford one. But the biggest challenge in the civil justice system is that you don't have a right to an attorney, and you may be losing your home. You may be facing, you're trying to get your unemployment benefits. You can't get through, but somehow an attorney can get through right away, right? There's a difference in what level of access you can have, and not just the level of access, but actually your case outcome, right? So, there are studies that show protective orders. You have a 32% chance of getting a protective order on your own, but with an attorney, it's an 83% chance. So when you're just thinking about the range of issues in the civil justice system, and I will sort of highlight them for you, but it is massive because it covers housing and foreclosure, it covers public benefits, it covers immigration, it covers life and health planning. If you think about the amount of people who are facing health issues and are passing away from COVID, et cetera, and then, what do they need? Do they have the documents in place to protect, their assets if there's passing? Do they understand what probate means? Can they have access to their homes if someone passes? All of these issues, and I should mention, obviously abuse and neglect also fall within this space. There have been a lot of reports of, we know that there's fears and reports of abuse, domestic violence, abuse against children, the elderly, going up during this time of quarantine and being in lockdown and maybe being trapped with your abuser. And so all of this falls within the civil justice space. So I think one of the key access to justice issues in our space is that it's so huge and people already do not have access. So to begin with, before the pandemic, only 20% of the people who needed help were getting help with the civil legal problem. And so now you can imagine that the numbers, just the volume of cases is going to increase because the number of conflicts are going to increase. And so that in itself is a huge problem. Pre-pandemic, another huge problem was that people did not even realize that they had a legal problem. So in the civil justice system, it's very easy to think that, it's not very easy, but it's not well known necessarily to people. So you may be living in an apartment that has mold. And so your child may be having, you know, asthma symptoms that are flaring up, and you think that's a health problem. I have to deal with my child's health problem. You may not know that there's a legal solution to that problem, to the point that Kerri was trying to make, that having an attorney could solve and have long-term solutions, you know, for some of these problems that don't even present as legal problems. The other issue is that right now, a lot of civil cases, both in administrative hearings as well as courts, have not been moving forward, and are now just starting, the courts are starting to reopen and hear these cases. But we do anticipate a tsunami of cases, both in evictions and consumer debt, and then in the many other cases. One of the issues that we have seen through even the emergency, when a lot of cases were not moving forward, but something like domestic violence cases were, protective orders, was that each jurisdiction, you know, each county, each court, even each judge within courts had different processes that they were following. There was a lot of divergence, and there wasn't a way for us to really let people know this is the process, this is the way. A lot of the advice from the courts was that you actually have to call each court to make sure that, you know, you're moving forward with the process. So as we now look to things opening on a vast scale, and we look to kind of keeping up with what is going on in all these jurisdictions, and what are people actually facing in court. You know, the issue of remote hearings is of great concern to us, as, you know, obviously some of these larger dockets, social distancing, and how are they going to run those protocols? We don't have details necessarily from the courts as to how that's going to proceed, what kind of mechanisms there are to help funnel people to the right services they may need. You know, some people may need just the rental assistance. Some people may need social assistance, housing counseling, or consumer counseling. Some people may need just, you know, the advice of an attorney. And those are the kinds of systems we're trying to put into place now and work on through the task force, so that, you know, as we're anticipating this huge glut, how can we make sure people actually get the help that they need? How can we make sure that there's enough public information out there for people to have the, you know, the phone number or the websites or wherever that all this information is housed? How can we make sure it's available in different languages? How can we make sure that the people who don't have access to technology, Wi-Fi, don't have a computer, how can we reach those people? Because those are going to be the people that need help the most. And it is very challenging, and it's time to think about how to reach people in those ways. So, you know, what we are considering, and that's the reason that we had to bring in a lot more people and form this task force, which I can talk about later, and how you may be able to get involved, because this, honestly, the access to justice issue in the civil justice system is very large and very broad, and we're thinking on multiple fronts how to make sure that we at least make sure people know that if they have a legal issue, and make sure that they get this help and support they need. I'll stop there.
Thank you so much, Ms. Shah. Appreciate it. So I want to go back to Professor Sinha. You talked a little bit about the limitations on people's time to talk to their lawyers and the number of times that someone might be able to talk to a lawyer. What impact does that have on the lawyer's relationship with the client and on the lawyer's ability to prepare a case?
Oh, it's a great question, Professor Goodmark. The impacts are tremendous. So I've been doing my best to talk to folks who are doing this work all over the country since March. And, you know, we teach our students, the first thing you have to do when you get a case and you're handling a serious criminal charge is you have to build a relationship of trust with your client. And that's the first thing that leads to a successful outcome. And that initial step is something that we've all learned to do in an environment where, you know, if somebody is upset or down, we can touch a shoulder, we can make eye contact, we can be in a physical space where we can build that relationship in a better way. And everyone I've spoke to is having tremendous difficulty translating to this environment. I spoke to a lawyer this morning, and she was saying she hasn't met 90% of her clients, and it's a real difficult process of working back and forth, lawyer with client, going over the evidence, talking through strategy, and none of that can be successful or productive unless there's that sort of initial relationship open communication and trust. So the trust piece is an issue. The regularity of communication is an issue. In complex cases, especially homicides and things like that, you have to work with your client for hours and hours on end, you know, really understanding the case and making sure that both of you and your client understand the case. And of course, that's gone down to 5 to, you know, even less % of the time you had before to do that. And of course, that greatly impacts outcomes. It impacts outcomes in a different way that's worth touching on, which is that on both sides of that relationship, both for clients and for the lawyers, there's been, as there has been in the regular population, there's been a tremendous amount of increased anxiety and stress that's translating to the really difficult and complex practice of trying to represent somebody charged with a serious crime and for which there are many myriad consequences. And so all of those things are adding up to you know, increased difficulty, substantially increased difficulty in achieving successful outcomes, starting from the very first minute you get handed a case.
I also wanted to follow up on the point that you raised about the inability to see evidence or to share evidence. Are there legal remedies that you're thinking about that might address some of these deficiencies in our ability to represent clients to the best of our ability?
Right, so that's a great question. And there have already been a number of lawsuits around the country suing various jail and prison facilities for denying right to counsel and access to counsel. And some of them have been successful and some of them have not. Some of the more successful ones have resulted in the facilities acquiring things like tablets so that they can be distributed to the folks who are there, and discovery can be viewed in that way. So that's one thing that's been done. And the other thing is, you know, there's a sort of just a resource problem, even in the facilities that are making those types of solutions available. As many of us here know, a lot of evidence now in this day and age is hours and hours and hours of body camera footage. And the ability to review that when you're sharing resources with, you know, a number of other clients or a number of other folks who are residing in these facilities is really diminishing your ability to do that. And so what we're seeing is, for the folks who have started to litigate this in individual cases, the remedies that they've been getting are continuances or postponements, which, you know, is not a real remedy when you've been languishing in a jail or you know, a jail facility for months on end. So there have been efforts, some have been successful, and those are things we're looking into. If you know, if we start, when we start, I hope is what I mean, when we start representing folks here in Baltimore again this spring.
Yeah, I wondered about that catch-22. The remedy would simply mean that you would stay in a position longer where you're more likely to be infected. I know that one thing that has been talked about quite a bit is the need to decrease the jail and prison population in order to decrease the spread of COVID, which could have the side effect of alleviating some of these access to justice concerns. Have you seen that happening?
Yes and no. We've seen it happening. We saw it happening, I want to say, especially in April. You know, a number of folks across the country charged with misdemeanors, especially, were released. But that's why I say yes and no, because that's a real small slice of the population. And one of the things we've seen, or one of the areas we've seen facilities do a particularly poor job, is in the federal system and in generally the state prison system overall. You know, as we've all been talking about, these have become COVID hotspots. Some of the highest prevalence of infection have been in jails and prisons, particularly in prisons. And so prisoners, folks who have been convicted, who've already been convicted of a crime and are serving a sentence, have sought what's called compassionate release, which is the ability to get released before your sentence is over for extraordinary circumstances. And the reticence of both prison officials and courts to actually release people who are at an extremely high risk of contracting COVID and having serious health outcomes, if not death, it's been astounding. So you might have heard the news, just last week, there was a woman, Safaria Johnson, she's 36 years old. She had asthma. She sought compassionate release at a Federal Bureau of Prisons facility. She was denied, and she died. And that's one that made the news, but it's happening all over the country. A federal prison system is among the highest, among the highest death rate of all prison systems in the country, and it's a revelation, as I think both Professor Lowrey and Ms. Shah were saying, a revelation of sort of this just deeply entrenched unwillingness to rethink how we do things in the legal system overall, despite unprecedented circumstances. So the short answer to your question is yes, there were early steps taken. I think across the board, there were sort of small slices of folks released, but overarchingly, I think not nearly enough release has happened. The Prison Policy Initiative, along with the ACLU, conducted a study of state responses to the pandemic, and obviously the conditions in the facilities was one thing they looked at, and another was how the states were dealing with release, and no state got above, I think it was like a D- or a D+ on their scale. So I can put that into the chat.
Thank you. And I just want to note in the chat, Lydia Giants has mentioned another issue that is coming up is the inability to have a confidential conversation knowing that somebody's case manager might be in the room. I want to turn to Professor Lowrey. You talked a lot about the crisis of eviction and the ways in which it impacts public health. And in the newspaper have been quite a few stories about changes to the law, at least in the short term, around evictions. Can you describe for us what those changes have looked like and what you think the impact will be, both in the short term and then as we start to go back towards a regular regime, what you expect to see happen?
Yeah, sure. So a really good question. Mainly what we're seeing is jurisdictions extending the eviction moratoria. We're not seeing that here in Maryland, but that's the primary way that jurisdictions are trying to address the issue. Obviously, that's a short-term fix. The other is trying to put money to the problem. So making sure that there are relief programs in place in jurisdictions to help people pay their rent and hopefully avoid eviction in that way. Looking forward, I really think that there's an opportunity for, like Professor Sinha was saying, there's this, real reluctance to change the way that we've always done things. And I see an opportunity here. Maybe I'm just, like overly optimistic, glass half full kind of person, but coronavirus is forcing us to see the glaring errors in the way that things are done. And so things like rent stabilization. We had a project last semester where we had housing law clinics in Prince George's County for families whose kids go to the community schools there to address their housing law concerns. We did a lot of, educating people on rent escrow and how to make sure repairs were done. And what we heard from them and from advocates at CASA of Maryland, who we worked with as part of that project, was that in Prince George's County at least, and I'm sure it's not the only jurisdiction in Maryland where this is the case, people were seeing increases in their rent up to 10% a year. And when we're talking about people who are already spending 30 to 50% of their income on their housing alone, that has a really significant impact on their ability to spend money on other things that are health promoting. So rent stabilization is one thing that we would like to do some more research in and do some advocacy around also. Right to counsel is a huge issue. We've talked about ways to make that happen, especially around coronavirus, with recent graduates who have either had their employment withdrawn or postponed, or the ability, so recent graduates pre-bar and law students having the ability to serve as agents for tenants. Under Maryland law, landlords can have an agent who is not a barred attorney represent them in court, but tenants don't have that same ability. So that's one change, an easy change to the law where tenants could have access to counsel either through an educated agent, a recent law graduate, or student. Other ideas are eviction expungement. A huge problem with eviction is not just that you're displaced from your home, but that it goes on your record. So renting in the future becomes more difficult because that's on your record. Public access to eviction filings is even an issue. Those are public records, and that has a detrimental effect on the ability for people to rent in the future as well, if people can see that there were failure to pay rent filings against you. So some policy ideas is to maybe limit access to that information while still honoring the spirit of freedom of information for the public. Yeah, so I hope I didn't overstep what you were asking me. I get real excited.
Not at all. I do wonder, you mentioned that in Maryland, we're not extending our eviction moratorium. Do you think that's a problem?
That's a loaded question. Yes, thank you for that leading question, Professor Goodmark. Yes, I think it's a major problem. I realize that eventually it's going to have to be lifted, but here's why I think this is a problem. One, the courts don't even know how they're going to handle high volume dockets like rent court. Obviously the whole court process is a problem in pandemic times, right? So standing in line for weapons screening, congregating in hallways to meet with your attorney if you have one, that's how rent court happens. There's dozens and dozens of people just waiting for their case to be called. The way that rent court happens is going to have to change, and since courts don't know how that's going to look yet, the court's not ready to handle the influx of failure to pay rent or eviction cases that's necessarily going to happen unless the eviction moratorium is extended. So that's just one, capacity is a major issue. And then you add to that just the fact that we're still in a crisis. We're in a financial crisis. A lot of people are just still struggling to pay their rent. And so until people can safely return to work and start earning a living again, it's a problem. And at least if the moratorium is not extended, programs and processes have to be in place to help people, before they lose their stable housing.
So I want to turn to Ms. Shah, and I want to build on the point that Professor Lowrey was just making, because one thing that you said, Ms. Shah, was that you expect to see a tsunami, essentially, of cases, not just in the context of rent court, but I would imagine in the context of all of the civil system. So what are we looking at in terms of people's access to meaningful justice, given the size of those dockets?
Yeah, I mean, it is a picture that is not pretty, and we are working on multiple fronts through the, we're partnering with the Attorney General on this task force. One of the first acts of the task force was to write a letter to Chief Judge Barbera and Chief Judge Morrissey to request an extension of the moratorium. We also wrote to the governor to request an extension of the moratorium. Currently, we're working on a funding request. There is funding that has come into the state, which is time limited, and it's called the CARES Act funding, which must be used by the end of December. And we have a series of recommendations where we think supports, so either for direct services or for infrastructure to handle this volume of cases that we're going to come in, to use part of that money towards those things. So it would be towards rental assistance, as Professor Lowrey was saying, but also other infrastructure needs including technology, including ways to ensure triage, like I was mentioning before, because the hard part is really thinking about, one, there's multiple things. For the people, for the organizations that exist that are providing services already, they will need to be scaled up, no doubt, right? And you need the manpower, the woman power, and you may need more technology or infrastructure in place. And so we are encouraging the use of those funds to establish that and put that groundwork in and be able to handle. But the other part is, there's going to be a call to action for pro bono assistance, because there is a limited pot of funding that goes into funding the community. Because there's no right to counsel, there's no state funding directly that's allocated to ensuring that people have legal representation, have legal information even. And so there's got to be a call to action. And we have a committee on the task force, for example, that has the deans of both law schools, that has law firm partners, that has corporate counsel. And we're looking at how do you do a massive sort of call to action. And then when you do a call to action, you have to have the infrastructure in place to bring all these people in, to match them, and to working with all those organizations to do that. So I would say we're working on multiple fronts: one, in prevention; two, in sort of triaging and figuring out where do people need to go; and three, in trying to figure out how can we build capacity, either through funding, through infrastructure, or through pro bono.
I would imagine that another thing that this has all revealed is the inequity that exists in terms of access to technology. So much of our contact right now is through means like Zoom. And what does it mean for our clients in terms of their access to justice when they don't have access to that technology?
Yeah, that's a really good point, Professor Goodmark. So initially, when the civil legal aid organizations had to pivot, when the emergency started, a lot of their services were court-based. So they actually had a room in court. They would be able to meet clients in court. A lot of the programs that we have set up are actually court-based. So one, when the emergency started and courts had to be closed, they had to figure out how to reach their clients outside of that physical space. And so, all the organizations work to figure out, okay, what platforms, how do we engage, et cetera. And the finding after like a month or so of trying to figure out all of this stuff was really, it's only the phone. Really, for low income clients that need to have access either to legal information or work with their attorney or even engage in remote proceedings, for a large swath of the population, low-income population, we were finding that the phone was the most effective. And then what Professor Sinha was talking about, you miss out, you lose out. If everyone else, say, in your hearing is on a video conference and you're participating by phone, especially if you're new to the system, to even conceive of this as being like your court hearing, and you're trying to participate by phone, and there's already so many power imbalances that exist in the court proceeding when you're there, but to do it in this remote setting that's so alien and new is another whole layer. We also have a data committee that's working on, that's working on looking at the state and kind of looking at the technology barriers. So the court is going to be moving to Zoom for government across the board. At least that's what we've been informed. But we have done an analysis of counties where, what do you need to access Zoom? And then those counties don't even have the speed, whatever the upload speed is. And so we have a map that kind of shows where that's deficient, so people can't really even access it in the most basic way. So these are challenges. And then I apologize. There are different, we're trying to collect the data. We're trying to get this information to the court. There's been a lot of information, obviously, and concern about, well, how can kids access education remotely? And we haven't seen the same level of kind of understanding that people cannot access justice if they don't have technology. And we're hoping to increase awareness and provide some data behind that to push that forward.
Thank you. So I'm continuing to ask questions because there are no questions in the chat, and I will continue to ask questions until people want to pose those questions. And so my last really planned question for all of you has to do with how we can be helpful. So there's so many of us who have some skills or some abilities that might be able to be helpful in this time. What resources are available to help with these problems, and how can people get involved? And Ms. Shah, I'll start with you.
So we, through the task force, we have been working on the task force since June, and we were pretty sure that we needed student assistance right away. We worked with both law schools, and we have about 10 students that are working currently to help staff the 10 committees of the task force. And I know that some of our summer students are going to be rolling off. And so we would appreciate if more students want to get engaged in those ways to assist with the actual substantive work of the task force, which includes, you know, everything from researching policy issues, solutions, and helping with, helping with, you know, we're gearing up for the legislative session, and so we're looking at sort of assistance with, you know, what needs to go to the courts, what needs to go to the executive, and then also the legislative solutions. So that's one way. And you know, as things start up, I'm looking for creativity from the schools. Some clinics have approached me, both from UM and UB, to say they want to support the work of the task force. And I think there's interesting things that are happening across the country as courts start opening up. You know, we need observers. We need people to be out there looking at what's happening with these remote hearings, so that we can actually have data and we know what's going on. And so we also are looking at, you know, what are other schools doing? How can students assist in trying to help us monitor and observe and capture some of this information as well.
Thank you. Professor Lowrey.
So this is just an opportunity for me to pitch this project that we're collaborating with the School of Social Work on. We were really fortunate to receive a seed grant from UMB's Center for Interprofessional Education to assist with developing a collaborative between the School of Law's clinical program and the School of Social Work. So if you're a student who is going to be in the public health law clinic, a medical legal partnership clinic, mediation, fair housing, or just advice, you're already going to be involved in this project. But if you would be interested in helping, we can use all the help that we can get. So look up, I will put my email in the chat and you can email me. Basically what we're doing is starting a month ago, we're in the process of planning right now. We are going to be developing a project to do kind of the legal triage that Ms. Shah was talking about, you know, educating tenants on, you know, what are your rights? How do you negotiate with your landlord? How do you set up a payment plan? Doing housing counseling for tenants and also for small landlords, and making sure that people know where to go for social supports and referring folks to mediation and to direct representation, you know, where that becomes necessary. And then as we're also looking at policy development, so identifying where law and policy can change to alleviate some of these recurring issues that we're seeing as we do the direct client work. So it'll be a combination of team-based law students, law faculty, social work students, and social work faculty serving clients and also identifying where we can make changes to law and policy in order to address some of these systemic issues that have always been there, but that coronavirus has shed a light on.
Thank you, Professor Lowrey. Professor Sinha.
So a couple of things. For folks who want to get involved, in particular with compassionate release, both federally and at the state level, there is a huge backlog of folks who need assistance with that, and there are a bunch of ways to get involved. So Families Against Mandatory Minimums, FAM, has put together an entire toolkit for people who want to do pro bono representation of people in compassionate release matters. I'll put their website in the chat in a moment. There's a separate organization, the Compassionate Release Clearinghouse, which is connecting pro bono lawyers with prisoners who are in need of pro bono counsel, because the federal defenders and public defenders around the country are absolutely drowning in this work. And so there's much to go around if anyone's interested. And then in the district in particular, there's a backlog of, I think, over 400 prisoners that they're looking for counsel for. So if anyone's interested in that, I'll put all of that in the chat. An opportunity to pump up the work of our students. I'm excited because the clinic this fall is going to take up some of that work. We're working with the federal defenders in Baltimore to handle some of their backlog of compassionate release cases. Another thing that students did last spring as the pandemic just started to unfold is law students around the country, and Professor Goodmark, you may remember this better than I do. Law students around the country formed an organization to essentially create a motions bank. So for these clients who we were talking about, who haven't been able to review their discovery or to see their evidence or see their lawyers in meaningful ways, filing motions arguing that they've been deprived of their due process rights and their right to counsel. And so that's a project that I believe is still ongoing, but I can double check if there are students who want to get involved with that student organization that was doing that. So those are some of the most high priority needs right now.
So in our last couple of minutes, I want to throw out a question that came into the chat to everyone. So we've all been caught a bit unawares by this pandemic, but we've learned a number of lessons about access to justice since it's hit. And so what can we do to be prepared for the next thing that comes along that creates challenges like this? What are the kinds of access to justice issues we should be thinking about now in terms of our long-term planning for a different kind of future? And I'll just throw it open to any of you.
So I'm happy to start answering that question. I think the short answer is that that's a complex question that has many dimensions to it, and there's no singular answer. From the criminal perspective, from the perspective of the criminal legal system, I think, as Professor Lowrey was saying early on in this conversation, the pandemic has just spotlighted and in many ways exacerbated existing disparities, existing power dynamics, as Ms. Shah explained. And quite frankly, we as a community, we as a society need to take a very critical look at overhauling it. We're spending so much time, or I'm spending so much time anyway, talking about jails and prisons. And the reason we're talking about that is because we use jail and prison as our default response to social problems, not all of which require that response. And so there's, as you know, I don't need to tell anyone that's listening in that, there's a movement right now to readdress our criminal legal system and look at the way we approach, way we structure our criminal legal system. And it's multi-layered. It's not just what's happening in the prisons. It's not just what's happening with policing. It's not just what things we criminalize and what we don't. It's top down, bottom to top, the entire structure. And so there's, I think we need to do more than observe. And when our local, state, and city councils and legislatures are looking at how to review policing and how to review what we're criminalizing, we need to step up and put, and express our concerns about these things. But I think the short answer is there's no simple solution, and it's not just one aspect of the legal system. It's every dimension, I think we all have to sort of play our small role in making our voices heard as states and cities and counties revisit this in this particular moment when there is momentum for that.
So Ms. Shah, I want to give you just a very quick last word on this.
Yeah, I mean, I would piggyback on what Professor Sinha is saying. I think what, this moment provides is an ability to reimagine and an ability to push through things that you know, advocates have tried to push through for a long time to help the system really work, you know, for people. I mean, rent court, consumer debt cases, there, you know, the court functions as like a collection agency. That's really, it's not solving problems. And I think if this, you know, pandemic provides us an opportunity to reimagine and craft solutions that are helpful now in the emergency, but put into place the structures that would be helpful for the long term. That is really what we need to use this moment for. You know, we need to have the reimagination. We need to be bold. We need to be achievable. But right now, things that, you know, it wasn't appealing to lawmakers before now makes sense. And hopefully we can use that momentum and really think critically and take advantage of it.
And that ties beautifully into Professor Pinard's question, which was how do we keep access to justice on the agenda? And I think we do that by continuing to try to push the kinds of reforms that many of us have been talking about for years. I would be remiss as the co-director of the clinic if I did not mention that a number of our clinics are doing really important access to justice work, particularly in this moment of the pandemic, trying to make sure that our clients continue to get the level of legal services that they deserve and that they should have. And in addition, that our Roar Center here on campus, which is serving victims of crime, is doing similar kinds of work as well. We're very proud of our ability to do some of this. And so thank you to all of you who make that possible. Thank you so much to our panelists, to Professor Sinha, to Professor Lowrey, and to Ms. Shah for taking the time to join us today. We very much appreciated your participation and all of the amazing things that you had to say. Please feel free to get in touch with any of us if you have further questions, and I will turn it over to Professor Danchin.
Thank you very much. It really was a tremendously interesting conversation, and thank you to all the speakers and to Professor Goodmark. So with that, say goodbye.